Do we have too much government?
We need to put people ahead of corporate profits.
This system is so lopsided. This threat is a real threat to democracy.
And I think that's really important. That's something we haven't been doing in this country for a long time.
Where do you start? What do you do? How do you do it?
Access to Democracy and other Eagan community television programming is supported by Thomson Reuters, makers of Westlaw Next and based in Eagan. Through Westlaw Next and other innovative online services, Thomson Reuters is the world's leading source of intelligent information for businesses and professionals. Online at thomsonreuters.com. And by U.S. Federal Credit Union, the member-owned financial institution offering service, value, and experience you can trust to the greater Twin Cities community.
Welcome. Access to Democracy returns. Your host, Alan Miller. We have a return guest, and I'm very excited to have her back with us, Justice Wilhelmina Mimi Wright.
Yes.
I always feel strange when I call a judge by their anything but Your Honor name. But I'm really happy to have you back here. And I just want to give a shout out to our crew, except for Mary Dahlke, who's the professional, has been with us for years. We have all MCTC cinema students here.
Wonderful.
Some of whom are interning, some of whom have passed their internship, and fortunately for us, come back and run the whole operation. They won't let me do anything but just be a pretty face in front of the camera.
You do that so well, Alan. Thank you very much for having me.
Justice Wright, who was on the court since 2012.
Yes.
And appointed by the governor, is now running for election. I can't say re-election because the first time on, you're appointed, and now you're running for election. You do have an opponent, allegedly. I don't know. Nobody has seen this person surface or anything, but you still have to campaign, something which I am very against, having judges with a good record campaign. And you, I understand, are the only justice who has served in all three of the courts, the district court, the Court of Appeals, and now the Supreme Court in this state, which is a pretty unique honor in and of itself. Give us a little background about yourself, and then we'll talk about some of the people who are supporting you.
Well, thank you, Alan, and thank you very much for inviting me to speak with you today. One of the challenges of being a justice and serving on the court and as well being up for election is that it is a very large state. I am very committed to having an informed electorate, and so you are helping me meet the challenge of informing Minnesotans about me so that when they go to the ballot booth and they turn over that ballot and they see that list of judges, they won't have the normal reaction that many Minnesotans have, which is, I have no idea. They will have a little more information so that they can make an informed choice.
That's absolutely true. And in many cases, I won't check the name of someone that I have no history or background or idea about. Now, generally, I make it my business to know the ones who are running in my area so that I'm at least conversant with them.
Yes.
But there will be several million people going to the polls, and does it say incumbent? I think it does say incumbent on the ballot.
It does say incumbent, which indicates that I have experience in the position. It won't indicate that I have served on all three levels of our state court system, so I appreciate you mentioning that, because that's, for me, very important experience that I draw on every day as a justice on the Minnesota Supreme Court.
And you have so much experience before you ever became a justice. Tell us a little bit about that. You clerked for a federal judge, if I'm not mistaken.
I did. I served as a law clerk for the Honorable Damon J. Keith. Judge Keith is a judge on the United States Court of Appeals for the Sixth Circuit, and so that is a federal appellate judge. I did that right out of law school, which is typical of law clerkships.
We might mention the law school with honors, which was...
I attended Harvard Law School and graduated from Harvard Law School, and prior to that, attended and graduated from Yale, so had some divided loyalties when I moved to Cambridge from New Haven, Connecticut. So right after law school, I clerked for Judge Keith, which is one of the most formative experiences that I've had in my career.
And helped establish you in terms of your own future.
Well, I draw on so many of the experiences that I had with Judge Keith. He really helped show me what I know and live today as a justice on the Supreme Court, which is that the law affects everyday people in their most important affairs. And while you want to have judges or justices who are learned in the law, very experienced, very knowledgeable, because the legal issues that we confront are very difficult issues at the Supreme Court. Many times there's no precedent, and we are creating the precedent. We call those cases of first impression. But what's important, so you want to have a justice who is well educated, who has a very good, strong work ethic, who is intellectually curious and is willing to work hard to get to the bottom of the legal issue. But you also want, I think, a justice who doesn't lose sight of the humanity that exists in the case. The case is inhabited by everyday people, real people who have an important legal issue that needs to be sorted out. Either their
Sometimes
business,
their lives are dependent on the decision of your court.
that can be the case, absolutely. And sometimes it's their business, sometimes it's their livelihood, sometimes it's their family, sometimes it's their freedom. These are no small measures in the life of Minnesotans. And so it's important, I think, that I can draw on the experience that I've had, other experience that I've had after leaving Judge Keith's chambers. I practiced law in Washington, D.C. at Hogan and Hartson, which is a large law firm. My area of expertise was litigation, and I represented I represented school districts throughout the United States that were engaged in the hard work of figuring out how to provide a high quality education to all of their students. Many of these school districts were under court-ordered desegregation plans. Others were voluntarily engaged in desegregation. And for me, my job was to help advise them about what the law was, how they could comply with the law, but as importantly, how they could do so in a manner that would ensure that their students were receiving a high quality public education, something that I benefited from when I was growing up as a child in Norfolk, Virginia. My school district was one in which it was under a court-ordered desegregation plan. And one of my earliest memories was my mother recognizing that the school district was not complying with the court order, and that in our neighborhood, which was a racially segregated neighborhood, we had a school that was not equal to schools that were in white neighborhoods across town. And she made it a point to go to the superintendent's office, uninvited, but with an appointment, to advocate for her children, to say that we deserved the opportunity to attend a school that would give us the quality of education that she thought we deserved.
So you got an early start in seeing how the law was important and how it affects people's lives.
You are exactly right. I got an up-close and personal education in the law from a non-lawyer, my mother, and understood it through the lens of what was most important to me, school.
Now, did you also serve as a federal officer in some capacity?
Yes, I did. After moving to Minnesota, I became a federal prosecutor. And so that meant that I worked as an assistant United States attorney representing the United States in criminal matters. So now I have the civil experience, and I also bring that criminal experience.
You have really been on all sides of, I mean, you bring experience that's almost unique in terms of running the full circle, the full gamut, which is why I assume that the Bar Association of the state of Minnesota has just about unanimously endorsed you, among others. And who are some of the other organizations that I can't go through the list, and in the list of names, it's overwhelming.
Well, we have the American Academy of Trial Lawyers, the Minnesota chapter of that organization, which is an honored organization. Membership is an honor to participate in that organization, to be a part of it. And they represent lawyers in civil practice on both sides of the case. They represent the plaintiffs who are bringing the case, and they are lawyers who represent the defendants who are the cases being brought against. And so it really is a broad base of lawyers who appear in court and who know what it takes to be a good judge or justice. And so it is a real honor to have them give me a vote of approval, because their work, their livelihood really depends on having a good, strong, fair, and impartial court.
But as I was researching for this interview, I could not get over the number of legal organizations and other organizations running the gamut of really our entire society, plus hundreds and hundreds of individuals who have endorsed your re-election or your election,
Yes.
which really is to reconstitute yourself in the court.
Well, it is an honor, and I don't take it for granted, and I frankly don't take the vote for granted. Growing up in Virginia, you understand the true value of participating in our democratic process by voting. And I want to honor the citizens of Minnesota by making sure that they have information about me so that they can cast an informed vote, one in which people understand what my qualifications are, they can understand the experience that I have, they can get some biographical information about me, and then they can go into the ballot booth armed with that information and make a choice. Now, of course, I hope that choice is for me, but to me it is as a matter of respect for Minnesotans that I engage in an active and vigorous, certainly nonpartisan, because judges are not partisan and should not be, but an active and vigorous campaign to help Minnesotans who will be casting a vote to understand who I am, what my experience is, and why I deserve an opportunity to be a public servant for them.
And judges should not be put in a position where they have to run for office like a political candidate, in my opinion, where they have to raise money like a political candidate. And I see really a conflict of interest. Somebody has to raise money, and then that person appears before them in court. That certainly does not present a level playing field. Now, you have a way of doing that that's rather unique.
Well, I share your concern, and I'm sure the concern of every Minnesotan, that how can a judge be fair if a judge is out raising money for their campaign and knows who's making a contribution? Wouldn't that person then get favorable treatment from the judge? And to alleviate that concern, to take it completely off the table, my campaign's financial work is completely screened from me. I have no idea whether anyone has contributed to my campaign. the contributions that are raised by individuals that do not tell me what they're doing, how they're going about raising that money.
And you don't want to know.
I do not want to know. I would not want to impugn or denigrate the integrity of our judicial system and our judicial branch. You know, I am a steward of our judicial branch, of an institution that is so much bigger than I am, and that has a wonderful reputation that is earned by many people who have served on the court well before I ever served. And I want to leave our institution as good as or better than it was when I arrived. And so I think making sure that I am screened from any knowledge of who is making a campaign contribution is extremely important. Do I have the right to know? Sure. But do I exercise that right? Absolutely not. And that is so significant and important to me.
I remember vaguely, back when I was in law school, it was about the same time that Lincoln was president, but give or take a year, that the Minnesota Supreme Court had the reputation as being one of the best courts in the country. There were a handful of courts that people, when you would say, well, that decision came down from the Minnesota Supreme Court, people would pay attention more than they would some of the other courts. And I think that that reputation has been maintained. We've had some wonderful judges, one of whom retired a year ago, replaced by another wonderful judge, who's going to be a guest here today, as a matter of fact, and is drinking coffee in the outer office as we speak. But David Lillehag, who's now the new justice on the court. A couple of years you were the new justice, and now it's Justice Lillehag.
Yes.
The court is a very collegial group, even though philosophically there are some differences there. And Judge Anderson would always say that that drops at the courtroom door, and the job is to do the job of the people as best each person can do.
I could not say that better, and I absolutely agree with Justice Anderson on that point. I think the court is such a strong court because of the diversity of the experiences of the members of the court. We come from a variety of different backgrounds. Some of us are native Minnesotans. Some of us have grown up elsewhere and chosen to be Minnesotans. Some of us have had experience in government practice, others private practice, many with a combination of the two. We live in various parts of the community. We share a commitment to justice. We share a commitment to making sure that the work of the Minnesota Supreme Court is of the highest quality and is what the people of Minnesota deserve. We come to our work well prepared, having read the briefs of the parties.
Understaffed, but well prepared.
Well prepared.
You don't have enough law clerks.
Well,
budget being what it is, it affects everybody, but it shouldn't affect the judiciary, and yet it does.
Well, it shouldn't affect the quality of the judiciary, and so we work to overcome any challenges that may be presented by the budget, because the people of Minnesota deserve that. And so when we come into the courtroom, it is the first time that we've heard each other's ideas about the case. We listen carefully to the arguments of the lawyers, to the questions of our fellow justices, and we learn about the case in that oral argument. It's very important. We've read all of the briefs. Now it's a time to test our ideas about how the case should be decided. After that oral argument is finished, we leave the courtroom. Typically, we go directly to the conference room where we sit down. Only the justices are in the conference room. one member of the
As it is with the Supreme Court, United States Supreme Court.
That is exactly right. And that's the way it should be. We are the people who are deciding the case.
Well, the Minnesota Supreme Court is known as what's a hot court. A hot court being that when the judges walk in, for the viewers anyway, they know the case. They have already read the briefs. They have already possibly discussed it with their staffs. They have a feel for it. Oral argument, in my opinion, rarely changes a case. Every once in a while it will, but it's down there based on the law and based on the arguments. And so you go from the argument right to conference.
Yes, and these are hard cases. So many times you're looking at the case and you can see one party's point of view and you can see the other party's point of view. So I think you're right, we are a hot bench. We are very well prepared. We vigorously engage in the oral argument with the lawyers, testing our ideas so that we can make the right decision. We want to clarify a particular point of law, or we want to clarify a particular fact that may be so important to our decision making. That's a very important interaction that we have with the lawyers, and frankly, the lawyers of Minnesota are top-notch. The lawyers that we see come prepared, they represent their clients well, they respect the court and help us decide the case by answering our questions and being prepared. We then go into the conference room, and as we discuss the case, that's the first time we hear what our colleagues are thinking about the case. You can learn so much from that discussion, and I know I can speak for myself that my view of the case can be shaped by the conversation, we call it deliberations, that we have during the course of the conference. So you want diversity there. You don't want everyone thinking the same thing.
As I understand it from speaking with other justices, they don't get heated, the conversations. You will certainly have different viewpoints, and there will be a majority and minority opinions often, but no rancor among the justices.
That is my experience, and that's what I love about our institution. We are one of the few institutions where we can have civil discourse across difference. We don't always agree, but one thing that one should always look for in our decisions when we don't agree is the dissent. And I think what you will see is that dissent within the first paragraph typically says, I respectfully dissent. Well, respectfully says it all, I think. And that's, in my view, again, honoring the institution of our court. And it is honoring the colleagues that I have, that I'm serving with, and recognizing that we come through our experience to the court, to the decision, but it is for the public service that we work.
Now, every once in a while, you'll get a case, and 2 days ago, as a matter of fact, the Seagate case came down, an arbitration case. I won't go into the facts of it, but there were about 20 parties to that case, or at least 20 amicus curiae, friends of the court. How do you handle a case where there are, number one, the time for argument I know is limited. All those people don't get the chance to stand up and argue.
That's correct.
But the main parties do, but they all submit briefs. What a burden that has to be on the court to have 20 different sets of briefs coming in from all these parties who are present. There's so many lawyers in that case, I don't think there was room for any visitors in the courtroom.
Well, you ask a good question. You are correct that the amicus, the friends of the court, do not have oral argument privileges. So it's the lawyers representing the parties who argue the case. But we read all of those amicus briefs. They help give us context for the decision in which we will be making. Now, we are going to decide the case according to the rule of law. But understanding the practical implications of a case can be something that an amicus brief, a friend of the court's brief, can be very helpful in doing. And I think when we have those amici, it is just further evidence that every case that comes to the Supreme Court is an important case. It's important to the parties. It's important to the development of the law. And we want to get it right. So you're right, that was a case in which there were, people were cheek to cheek. I'm not going to say which cheeks, sitting in the gallery of the court. But that is another thing that's so wonderful about our court, is that we provide access to the public. You could come as any citizen and sit in that courtroom and hear that oral argument.
And I have.
And see democracy on display, the judicial branch of our democracy on display. And so it's important. My judge wrote an opinion, Judge Keith, that said democracy dies behind closed doors. We want to have the full airing of the oral argument and the case presented so that Minnesotans can come to the court and see the oral argument. But if they can't come to the court and see the oral argument and they have access to the internet, they can go to www.mincourts.gov, and on that front page of the court's website, in the bottom right corner, well, midway, I would say, on the bottom right side of the opening page, you will see an opportunity to, one, read any opinions that have been released that week. You can go back and read the archives of opinions, decisions that have been rendered, and you can also see the oral argument in the cases that have occurred. That's an important piece of transparency that we have in our government system.
Minnesota Supreme Court opinions, and you'll find that day's opinions.
Yes, that's exactly right.
Which is what I did before this interview.
Wonderful. And I think that's a real important part of the transparency.
We have only a minute left.
You're kidding.
So it goes so fast.
You make it so easy, it does go fast. This is wonderfully enjoyable.
A message to the voters from Judge Mimi Wright, who is running for election to the Minnesota Supreme Court. I call it re-election, really, because she's a sitting justice.
Well, thank you. It is an honor to serve the people of Minnesota. I take that honor very seriously. Not only the work in the courtroom and the work in chambers of writing the opinions, but I really relish the opportunity to educate the public about the work of the court. Why? Because the courts belong to the people.
And I thank you so much, and I wish you, Judge Wright, the best of luck.
You are so kind. Thank you. This is such an honor and a pleasure to be here.
Oh,